Okay.
I can say what he is. It smells like old hot dog water. That's not a crime. Because when I went to St. Clair Shores jail for cyberbullying, which is a bullshit cause, okay? When you plead guilty to a crime, they shut off your checks. Am I making this any clearer to you? Because this is an LD courtroom. Apparently, you're LD.
What is an LD courtroom, sir?
Starting to say, just give me the bond and let's get on with this. You're dragging this on.
So, when you're standing in a jail cell, telling your video arraignment judge that she is learning disabled, is that A, you being a pot calling the judge black, B, you proving that it takes one to know one, C, you guaranteeing yourself a lukewarm mystery meat dinner over Thanksgiving with your comrades at the Wayne County Jail, or D, all of the above. If you selected any of those, congratulations. Your last fart had more brain power than this guy. He's fun to watch. After that, stay tuned for a 19-year-old who got caught with Xanax and who claims he needs his weed for a chronic back problem. What's wrong, nerds?
In the matter of the state of Michigan versus Jeffrey Biggs Jr., 232366.
Good.
Counsel?
Christopher Shemke appearing on behalf of my client. It's time we consent to the matter being heard via Zoom.
Okay. And Mr. Biggs, your name for the record, please.
Jeffrey Alvin Biggs Jr.
Okay. Well, so Mr. Biggs is in custody based on a warrant this court issued October 3rd of 2024. He'd previously been arraigned in this manner. And so the court is indicating the warrant would be recalled. We'll set this for probable cause conference on December 4th.
9:45.
9:45 a.m. And as to bond counsel.
Your Honor, Esteban, my client is currently 38, no probation. He indicates he's not on probation parole. He doesn't have any other pending cases. He lives with a friend in a local city. He does receive SSD for mental illness. He's had that since 2011. Indicates that he graduated high school in 2005. I know that financially he won't be able to make any monetary amount as it applies to postings. So we'd ask if a personal bond were not to be granted, we'd ask for a 10% or cash surety provision. Thank you, Judge.
Okay, so there's a few things going on here for Mr. Biggs. Well, Mr. Biggs, let's see. So I'm just going to go through the procedural history here for a moment because it's important as this court determines what the bond is going to be in this matter. This matter is alleged to have occurred November of 23. The defendant was set to be here January 25th of 24. He failed to appear for his arraignment. Warrant was issued on January 31st. Sir, you'll have an opportunity in a moment. Then on June 6th of 24, this matter was supposed to be, it was scheduled for July 11th at 9:15 a.m. And then there was a writ that was sent because Mr. Biggs was in the Macomb County Jail. So on July 11th of 2024, the arraignment was held, scheduled this matter for probable cause conference July 18th. The court ordered a $10,000 personal bond at that point, as defendant was serving a sentencing with an expected release date after the probable cause conference. On July 18th, the Macomb County Jail did not log in with the defendant for the probable cause conference, so the court adjourned it to August 1st. August 1st apparently was not a good date for the Macomb County Jail, so we adjourned it to August 8th. August 8th, Mr. Biggs was present. However, his attorney was late. Then after Mr. Biggs was on Zoom for a while, the Macomb County Jail logged him off because they were tired of waiting for his attorney. So then the court waived the appearance of Mr. Biggs and then set it for an exam on September 5th of 24. On September 5th of 24, the preliminary exam was not held because Macomb County Jail would not release Mr. Biggs due to an arraignment in 41B District Court. Adjourned the exam to October 3rd of 2024. October 3rd, 2024, defendant failed to appear and was no longer in Macomb County Jail. Immediate warrant to issue. That was the last we've heard from Mr. Biggs. Well, we didn't even hear from him that day either. And so what is it you want the court to know, sir?
I was like, I was in jail for the whole time, pretty much.
Well, when were you released, sir, from jail?
Yesterday.
Yesterday.
Yeah.
And which case was that on? Because there seems to be a lot of them for you.
There's quite a few.
Right. So which case was this one on that you just were released from jail yesterday?
Disorderly person out of e-course.
A what?
Disorderly person out of e-course.
Okay. Sir, let's just clarify something here. All right.
Yeah.
Sometimes I feel like I may look young, sometimes I don't. All right. But I'm not stupid. You were released from custody from Macomb County Jail. When were you released from custody from Macomb County Jail? Because that was not yesterday.
No. That was a different case. I was in, I think, October, November of 2024.
Correct. So don't try telling this court that you didn't come to court because you've been in custody pretty much the whole time, because that's not accurate.
Okay, that's not what I meant to say, but okay, man. You don't have to yell at me. I'm listening to you. Listen to your record voice. You don't have to yell. It's okay, man.
Excuse me. You are not going to speak to me that way, sir. What I don't appreciate is for you being dishonest and misleading the court.
I didn't mislead the court.
You sure did.
I've been in jail since.
Stop. You said I've been in jail the whole time, pretty much. That is what you said.
I meant to say I've been in and out of jail. I'm sorry, in and out of jail the whole time.
And sir,
Like this is a felony. So it should take precedent over any other case. But it doesn't for some reason. I don't understand why the court hasn't already brought me here. I've been arrested 4 times since I've been out. And you haven't brought me here for what reason? Because you don't have a case.
Stop right now. First of all, I don't get to bring you here. That's on the police department. So I don't know what communication occurs between the police departments, sir, and whether or not there's a case or not. That's for the attorneys to determine if they want to present the case to the court. Once the case is presented to the court by way of preliminary examination, then the court will determine whether or not there's evidence or there's a case. So the court will also note that there is a preliminary exam scheduled. However, because you are already in the Macomb County Jail, then their local 41B was conducting an arraignment for you, which apparently took precedent over this court's case. And perhaps that is from the matter from Macomb County Sheriff, December 31st of 2023, felony assault with a dangerous weapon, 2 charges of that. So I can see why they kept you there and didn't log you back in. Nevertheless, sir, you're very much aware that this matter is pending. Whether you've been arrested 10 times or no times, you know this matter is pending, and you did not do one thing to address this matter at all. Did you email into the court, sir?
I don't have an email, man.
Did you come into the court?
I came to one that dog pound and picked up my dog. I came to your police station to pick up my dog. I came to your police station and picked up my dog when it was stolen from me.
Hold on, let me clarify, sir. The court does not have a police department. The city of Wyandotte has a police department, not the court. So it's not my police department. And what about your matter out of St. Clair Shores, sir?
That's been resolved.
Okay.
They gave me a county year for it. I did a county year for it. For cyberbullying, which is a whole strike on the First Amendment. That's neither here nor there.
For what?
That's the whole thing against the First Amendment, but that's neither here nor there. I already done that. I did the jail time for it. It's over with.
Okay, so let's see. You have a matter from June of 2025 from E-Course, misdemeanor assault, and then you have another one from October 31st of 25 for solicit misdemeanor damage of property and solicit felony burglary. So which matter were you in custody for until yesterday?
I was at burglary anyway. I never burglaried anyway. What are you talking about?
Those were your charges. Oh, and then also public peace. So is that what you were just released on yesterday?
I already did the time for those already.
Sir,
What do you think? I just came from Wayne County Jail for doing the time for those.
excuse me. Sir,
Yes.
my question is, which one of those were you just released from custody from yesterday?
All three.
Oh, okay. All three. And so, sir, who do you live with in Newport?
Katrina, my friend Katrina.
And how long have you lived there, sir?
A long time. Not sure.
Okay. And you don't work?
No.
And so, sir, while you were in custody, were your Social Security disability benefits terminated?
Yes, ma'am.
And so have you started to receive those again?
No, ma'am. No.
And so then how are you supporting yourself then, sir?
What do you mean, ma'am? I've been in jail. I don't have to support myself. I don't have to support myself while I'm in jail. I'm in jail.
Well, you've been in and out of jail, you stated.
When I got out of prison, they gave him back to me. When I went to St. Clair Shores Jail for cyberbullying, which is a bullshit cause. Okay.
Excuse me, sir. You're on the record in court, so you need to really check your language.
Okay. Well, it's BS. It's a BS charge.
Okay.
I can say somebody is fat and smells like old hot dog water. That's not a crime. That's not a crime to say that.
To say what?
Never mind. I'm on the record. I'm going to keep it to the simple. When I got out of St. Clair Shores Jail, they gave me my check back. After 7 months, I had back pay. With back pay, I bought a car. With the car, I was going to and from Untouchable Tire. Okay, and then I got arrested again for something that happened in 2023 before this case even happened. Okay, I went to Wayne County Jail. They shut off my check. Look, when I pled guilty, they shut off your check. Okay, when you plead guilty to a crime, they shut off your check. They shut off my check. So I currently do not have a check. Okay, am I making this any clearer to you? Because this is an LD courtroom. Apparently you're LD. Apparently. So can I please go back to my cell now? Because you're
sorry.
staying. Just hold a sec. Can I think you go back to the cell? I go back to the cell.
What is an LD courtroom, sir?
Learning disabled.
Learning disabled.
Yes, ma'am.
You think this court is a learning disabled court?
If you give me no bond or give me whatever $10,000 bond, $100,000 bond, doesn't matter. Okay, just give me the bond and let's get on with this. You're dragging this on for no reason. You're gonna give me a bond. I'm not gonna pay.
Excuse me. Stop talking. Stop talking right now. I'm going to show you how much not learning disabled this court is, sir. Because you are the one that's been dragging this case on for your failure to appear in court. So this is what this court's going to do. This court's going to issue a $25,000 10% bond. In the event bond is posted, GPS tethered through the Wayne County Jail, not to possess or consume any alcohol or drugs unless prescribed. And sir, your lack of excuse me, I said stop talking, please. Your lack of respect for the court, sir, is not going to be tolerated. We'll see you back December 4th.
Thank you, Judge.
Have a good day. All right, let's go on the record in the matter of the state of Michigan versus Todd Stigger, 251646. And detective, your name for the record, please.
Detective Sergeant Devin Geiger, Wyandotte Police Department.
Okay, I'm going to have you please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you may proceed on the warrant.
On 11/25/2025, and approximately 22 hours, Officer Gardaki was dispatched to the area to report of a family problem involving the caller and a grandson. Upon arrival, officer observed an individual later identified as Todd Cameron Stigger staying on the north side of the house in the driveway. Stigger had his hand against the window screen as the officer was approaching him. The officer noticed that there was damage to the screen and asked Stigger if he caused the damage. Stigger stated that he did. He poked his fingers in there, but he did state that he lived at this residence. It was at this time that the officer requested consent to search the person for weapons for his safety. Stigger stated he had no weapons and consented to a search of his person. While searching at him, Officer Gardaki then felt a hard object inside the left anterior breast pocket of his jacket. It was a crumpled up ball of tinfoil, which was placed on a nearby window ledge, and no further contraband was located at this time. While speaking of Stigger, officer notes that Stigger stated that he was 19 years old and was smoking marijuana with his friend prior to coming to the house. Due to that and the contraband, the tinfoil wrapped up, which is commonly used as a packaged narcotics, Officer Gauranteeing asked if there was any fentanyl or any other dangerous substances inside that would harm him. And he decided to, at that time, search the item. Stigger reported that there was no fentanyl in there, but wouldn't report what was inside the package. Inside the package, Officer Gauranteeing located 15 white rectangular pills, which were through evidence or drugs.com, identified as alloprolozan. Stigger admitted that he did not have a prescription for these controlled substances. A match report was conducted, and it shows that Mr. Stigger does not have a prescription for alloprolozan. That's it, Your Honor.
All right. Upon examination, complaining witness, the court does find that the offense charge was committed. There's probable cause to believe defendant committed that offense. And counsel, your appearance, please.
Thank you, Ron. Your Honor, John Goldpaw, P 30758 on behalf of Mr. Stigger. Also, Your Honor, there is another matter.
Yes, there is, but I figured we'll do this one first.
Fine, too, because I've also talked to him. And,
Okay.
Your Honor, John Goldpaw, P 30758 on behalf of Mr. Stigger. Mr. Stigger, please put your name on the record.
Todd Stigger.
Okay.
Your Honor, as to the charge in 25-16-46, I have had an opportunity to speak with Mr. Stigger. At this time, he would stand in charge, waive a formal reading of those charges, ask for plea of not guilty.
Okay. The court will waive the formal reading. Sir, you do have the right to have an attorney represent you. And if you cannot afford one, you may have one appointed to represent you. And in fact, you've had an opportunity to speak to an attorney today. Is that correct?
Me, Your Honor.
Yes.
Yes, sir.
Yes, Your
Okay.
Honor.
All right. And the court has also signed the petition order for appointed attorney for felony matters. You do have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, Your Honor.
The court's going to enter a plea of not guilty for purposes of the arraignment. Schedule this matter for probable cause conference on December 4th at 10:15 a.m. as to bond counsel.
Your Honor, Mr. Stigger is 19 years old. He lives with his grandmother and his two younger siblings. Mr. Stigger is a graduate of Roosevelt High School. He has just recently seen employment at, I believe it's in Amazon in Brownstown. Your Honor, he has no prior criminal record. He does have, and is here today as well, for a misdemeanor of controlled substance. He's scheduled for a trial. I spoke with Mr. Stigger yesterday regarding today's hearing, not regarding the incident we're now addressing regarding bond. People told me how that occurred, what's going on, was ready, willing, and able to get here to resolve that issue. Your Honor, he suffers from some mental health issues. His grandmother, who he resides with, has been here since 11 o'clock this morning, concerned about her grandson. He was having, as she indicated to me, he's been so unnerved just about the whole situation because he had to be in court. He was really concerned that he was acting out of sorts. And that's what created him now being in custody. They called because of the disturbances, looking for help. He needs mental health treatment. He's well aware of that. His grandmother provided, Ms. Sanderson, who I've indicated is in court today, provided me with a package. To be quite honest with you, it's the only document she has, and I have not read it all. pages of attempts to get mental health treatment assistance for him, as well as his siblings, going back as far as his age of 14 and 15. He has a desire to join the military. However, he understands that he has to get these medals behind him as well. I'm asking for, on this matter, and the court wants to, and we're discussing this, we are going to request to arraign him only on the other matter now because of this, obtain discovery and seek a bond for both issues. So I just want to, we're trying to put out package, even though one's a felony and one's a misdemeanor. We're trying to package all of it. So I'm asking Your Honor for a bond, which actually I'm asking for a personal one in these matters. I know that they're serious. He's been here. He was willing, ready, willing, and able to address one issue, and then, as they say, it necessitating his grandmother's last night, which now results in his second charge or a second offense. It's a 2-year felony, but high court felony. We're asking.
Okay. So on the other matter, the court will, on the 251304, the court will wait for formal reading. And it's repeated not guilty. I'll indicate pre-trial not held.
I believe there's a discovery order in that.
I do not see a discovery order. Hold on. I do not see a discovery order. Well, hold on. Yes, there is.
Oh, he's still wanting.
I got you.
Do you have a back issue, sir?
Do I have back issues?
Yes. Why are you leaning on the podium?
I mean, I've had back issues since I was like, I want to say since like 13, 14 years old.
Okay, my point is, sir, you don't need to lean on the podium.
I got you. I'm sorry. Yes, Your Honor.
And sir, let's see. So you started working at Amazon?
Yes, Your
When?
Honor. I just started working November 17th.
Okay. And so before that, where did you work?
I worked at a newer distribution center, but that wasn't until what's the month for October? Until August. I started Myers Distribution in August, and I got fired from there about October 4th. And then it just took me a really, really long time to find a job.
All right. Well, you have a couple matters here that you owe the court from a bit ago.
Yeah,
Failed to
I
report.
understand that.
Hold on. There's a failed to report, which tells me that it was probably leading to scene of an accident first. I don't know.
Didn't see that in the
And then you have a warrant for your failure to appear in September in Lincoln Park.
I did not know of that.
Well, sir, you received a ticket, right? In Lincoln Park.
I received some tickets from Lincoln Park, but none stated that there was a warrant out for my arrest.
No, sir. The warrant's because you didn't show up to court after you received your tickets.
But I need.
I was put on a payment plan for that. I have one ticket to Lincoln Park.
Well, then, sir, you may have missed your payment plan, and then you didn't show back up to court on a show cause or what have you, and then they issued a warrant because you ghosted them. That's possible. So, sir, let me just say this, right? You don't have a prescription for marijuana, do you?
I do have my medical marijuana card, yes, but last November, I had gotten into an altercation. I had gotten pistol whipped, and my whole side was literally swollen sideways. sideways. I was dripping blood everywhere. And they ended up pistol whipping me, taking my wallet, and throwing it off onto the highway. My grandma can vouch too, Your Honor.
What does that have to do with marijuana?
My point with that is my marijuana card was in my wallet that when they pistol whipped me and threw it in a river, threw it in whatever they threw it in.
Okay. Well, sir, and what is the medical need for your medical marijuana card?
I have chronic back pain.
So do stretches. You need to have marijuana for your chronic back pain at 19?
Yeah, I do.
Wow.
You just see me. You just see me standing up on the podium, Judge. I'm telling you, I have back problems. My another thing, Your Honor, is my dad's mom. She had multiple sclerosis. So yeah, I do think it is appropriate for me at 19 years old of age to have a marijuana card.
Okay. All right, Detective, would you like to address bond?
Just no illegal substances, only prescribed. A bond to assure his presence in court. He's got a couple FTAs, so it's no concern. So $250 to $500 to assure his presence.
He's kind of showing it.
Okay, so here's the concern I have, sir. It appears as though you want some help with some of your challenges, correct?
I'm sorry?
Are you wanting some help with your challenges that you have, sir?
Like what, miss?
Your possession charges, or potentially your mental health challenges, or your continued use of marijuana at 19 challenges?
I mean, it's medically prescribed, so that's not the charge.
Mr. Steiger.
Just like
Mr. Steiger, the court asked you, do you want to get some help with respect to your mental health issues as well as your substance abuse challenges? That was the question.
yes.
Okay, sir.
Yes.
Let me ask, where did you get your prescription for marijuana from? From your treating physician?
I have it in my phone somewhere. It's some physician online.
Okay, did you go to a medical marijuana clinic, sir, and that person prescribed you the medicine?
No, ma'am.
Yeah, that goes across.
Do you have a primary care physician, sir?
No, ma'am.
Okay. Well, here's what this court's going to do. Given the charges that we have here, we have one pending charge, and then now we have a new charge. Given the concerns this court has for Mr. Steiger, and we now have a felony charge, the court's going to order on the 251646, the court's going to order a $5,000 10% bond, which, sir, is quite low on the bond, given the nature of your charges. On the 251304, the court's going to order a $7,500 personal bond. The court's going to order that you're not to possess or consume any alcohol or drugs that are not prescribed. Sir, that means if you have a valid prescription for something, you need to submit that to the court. Otherwise, it's a violation.
Yes, ma'am.
And I will let you know that when it comes to marijuana, sir, it's likely there's going to have to be a hearing on that. Because while it's prescribed by the doctor, you don't have a treating physician. So that's where this court has some concern. And just because a doctor's prescribing medication, sir, doesn't necessarily mean that's in the best interest for you. Look at the opioid epidemic that's been in this country, right? That was from doctors prescribing medications, and it's turned into something a lot more. So given your situation, that is what the court's going to indicate. The court's going to also order that you have to participate in random testing.
That's the drug testing, right, Your Honor?
Yes.
Yes, ma'am.
That includes marijuana at this point in time. Do you understand that?
Yes, sir. I do understand that, but now, is there a way that maybe I could get around that by proving to y'all that I have a certificate from them?
To go, you will have.
Hold on, counsel. Sir, let me be very clear. All right, because I thought I was clear, but maybe I wasn't. If you present this court with a medical marijuana card, there will likely be a hearing that this court will require before this court permits you to continue to use marijuana.
Yes, ma'am. Okay. Understood.
So until you have something from this court indicating that you can use marijuana for medical purposes, you can't, because you have not been able to show that you have a valid medical marijuana card from a treating physician.
Yes, sir. Yes, Your Honor.
That testing also includes, as part of your conditions for bond on both cases, that you're not allowed to drink either. You understand that?
Can't drink.
Oh, I understand that. I never
just want to make sure. Just wanted to make sure.
Okay, very good. And then counsel, I'm not sure if at some point you want to speak to your client or your client's grandmother regarding the treatment for we have here.
Well,
That might be helpful.
yeah. That's
Okay.
by the two. Do we have a date for the new pretrial? I don't believe it.
I think you're correct. I didn't pick it yet. Nope. We can put this for December 10th,
Yes, ma'am.
Oh, that's been.
11:15. Okay, thank you. Have a good day.
Good luck. I'll be in contact.
Thank you.